Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And
right out of the gate, we're introduced to a familiar face with an unfamiliar grasp of reality. This is not his first appearance, not his second, but his third time turning a courtroom into a personal soapbox. His court-appointed attorney immediately tries to withdraw, which tells you everything you need to know. When your own lawyer says, on the record, that they can't help because the arguments are detached from the law, that's a flashing red warning sign. This isn't strategy, it's self-sabotage. The defendant mistakes persistence for intelligence and notoriety for credibility, and the case hasn't even started yet.
And so then I can appoint a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is...
Here we see the classic sovereign citizen contradiction. He insists on representing himself while simultaneously demanding protection, accommodation, and validation from the same system he claims is illegitimate. Wanting to be left alone, while repeatedly inserting yourself into public confrontations is not a legal position. It's a lifestyle complaint. Courts don't exist to validate feelings of discomfort. The judge calmly explains the rules about recordings, transcripts, and procedure, but none of that matters to someone who believes suspicion is evidence and mistrust is a substitute for facts.
Audio-only recording, I was told that there's an objection to the audio-only recording, and I'd like to know, I don't feel safe without a recording, so is there any reasonable objection?
Well, first off, you can't record in the courts of law. If you'd like a transcript, everything is already being recorded by my court recorder, and I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So well, like I said, I don't feel safe without a report.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
Well, yeah, I have no desire to do that. All I want is to have fair and meaningful hearings. And, well, I mean, first off, I'd simply just like to be left alone. But other than that, I mean, to get fair and...
I get that, but obviously you had an interaction with somebody where they are alleging that, because today's date and time set for the arraignment. So I want to make sure that you understand, I need the phone, on the date and time in question, it is alleged that, because first let me do the arraignment part, because I need to let you know what exactly you're being charged with. All right, so you say you want to be left alone, but they are claiming that there was an interaction. Now, first off, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney if you got a 411 will be appointed to you by the court at public expense. Now, it is alleged that on November the 17th of 2022, while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500.
This section highlights a critical misunderstanding. Courts do not operate on vibes, fears, or personal distrust. The defendant claims he feels unsafe without his own recording, as if feelings override court rules. The judge patiently explains that official recordings already exist and that transcripts are available. Instead of acknowledging that, the defendant pivots to anecdotes from other courts. That's a common deflection. When facts don't support you, introduce unrelated grievances and hope confusion replaces clarity.
I'm going to caution you that anything you say can and will be used against you. So
I understand.
As to guilty or not guilty, that's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
Or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you, so that you don't have to say anything, and it automatically goes to not guilty. So are you pleading guilty, not guilty, or standing mute?
well, before I make a plea, you stated that I have the right to be informed of the cause and nature.
Now we reach the arraignment, the simplest stage of a criminal case. Guilty, not guilty, or stand mute. That's it. 3 options. The judge explains the charge clearly, the potential penalty clearly, and the rights clearly. Yet this straightforward moment becomes a drawn-out ordeal because the defendant treats basic procedure like a philosophical debate. This isn't about understanding. It's about control. He believes refusing to answer elevates him above the process, when in reality it just hands control right back to the court.
What I just told you what the charge was.
Okay, and you're stating that it's based on an interaction, so my guess is that you have no first-hand knowledge of anything that happened?
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. And that ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
You sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law.
This is where sovereign citizen jargon enters full force. References to federal statutes, deprivation of rights, and conspiracies are thrown out like magic spells. The problem is simple. Citing laws you don't understand doesn't intimidate anyone who actually practices law. The judge correctly points out jurisdiction and scope, but the defendant hears dismissal instead of explanation. He believes invoking federal law automatically negates a local charge. It doesn't and never has.
What you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor. The people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only thing I can do right now is ask you, are you pleading guilty, not guilty, or standing mute?
Can I have the name of that prosecutor that's bringing the charges? Because I've had in another case where a prosecutor stated at 3 proceedings away from the arraignment, she stated that after reviewing the video...
I'm going to take your response as being non-responsive, which is has nothing to do with being guilty or not guilty, so I'm going to enter a plea of not guilty for you.
Here, the judge demonstrates remarkable patience. He explains that an arraignment is not a trial, not a debate, and not a platform. It's a procedural checkpoint. The defendant keeps trying to jump 10 steps ahead, arguing outcomes before foundations are even laid. This is like refusing to start a race until you've argued about the finish line trophy. Courts move in order for a reason, and ignoring that order only delays your own case.
Well, I first have to clarify. You did say that I was presuming...
I don't have to clarify anything, sir. I'm being very fair with you. And right now, you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is do an arraignment. Nothing more can happen in this case until the arraignment happens. And the arraignment is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm going to enter a plea of not guilty for you so that I can protect your constitutional rights, because a lot of people don't know that they should. So that's why I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's going to be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either going to plead guilty, not guilty. If someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been forced to be pleading guilty. So by you saying everything else, that's all well and good, but it's not the time and place for it. See, this is the problem, is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process, and everything has to go in that process. And the process today is an arraignment. It's just an arraignment where I'm telling the individual who is alleged to be a defendant what the allegations are. And the allegation is that you violated a city ordinance, and that city ordinance is basically one commonly known as interfering with the police authority. So that's and letting you know what the charge is, and letting you know what the penalty for it is. And I've already stated. So again, I'm going to ask you, guilty or not guilty?
Well, I certainly appreciate.
When the judge enters a not guilty plea on the defendant's behalf, it's not coercion, it's protection. This preserves rights and prevents accidental self-incrimination. Ironically, the defendant objects to the very safeguard designed to help him. This reveals the core issue. He doesn't want fairness. He wants control without responsibility. The court can't allow that, and it never will.
I would advise settlement conference, and everyone can come back at that settlement conference. And if there's if there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial, because that's your constitutional right, and I just need to know which one you're choosing. So, all right?
Outstanding, because I'd like to talk to this prosecutor who I suspect is a criminal at this time.
Did you really just say out loud and on the record that you suspect the prosecutor of being a criminal? That was literally the dumbest possible thing that you could have said in that moment.
And I would like to...
First off, I'm going to caution you, Mr. Lanto. I'm going to caution you, and I'm going to caution you once. And the next time it happens, I will hold you in contempt, because I will hold anybody in contempt. I do not run a Jerry Springer show. I do not run a Jerry Springer show where the litigants are going to use words and things and call each other names. If you're going to refer, I'm not referring to you as a defendant. I rightfully could. Anybody who has charges brought against them is, for a moment, known as a defendant. If you look at a dictionary and look up defendant...
This part exposes another myth. The idea that judges are state actors conspiring against defendants. The judge explains his oath, his role, and his duty to the Constitution in plain language. This isn't defensive. It's educational. But education fails when the listener is committed to suspicion. The defendant interprets calm explanations as emotional reactions because admitting neutrality would collapse his entire narrative of persecution.
Right here, hang on 1 second. Copy of my... Sir, please, I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that, what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the Constitution seriously. So if you are implying that I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to it. So if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker, and I am not.
Well, I didn't. I didn't.
That's exactly what. I swore an oath to the Constitution that I put my hand on the Bible and swore to, and I'm telling you, I don't break my oath.
Okay,
so
would you agree
that implying that you're not going to get a fair hearing? That's my job, is to make sure that fairness happens, that due process happens, and so So I'm asking you, just as a matter of course, because this is the stage that we're at, is an arraignment. Are you pleading guilty or not guilty?
Well, you just said...
Or if you're not responding to that question, I'm going to enter a plea of not guilty on your behalf, and I'll find you standing mute to the question.
Well, I object to anybody making a plea on my behalf, and I just wanted...
I'm not making a plea. I'm just finding you. I'm just entering. I'm just saying that you are right now presumed not to be guilty. That's just your constitutional right to be presumed not guilty.
And then that means
your constitutional right. I'm not entering a plea for you. I'm just listing you as somebody who is right now not guilty. Because the Constitution says you are to be presumed not guilty until proven guilty beyond a reasonable doubt. So I'm not entering a plea for you. I am just merely stating that this individual is to be treated as someone who is not guilty.
Okay, and then, so if I'm presumed innocent of all the elements of the charge, correct?
No, you are presumed innocent until proven guilty. And you haven't had a trial yet. That's your other constitutional right. So if you'd like to set this for a trial, we can just set this for a trial.
Well, we just said that I'm presumed innocent until proven guilty, and then my question was, am I presumed innocent of all the elements of the charge? And I didn't get in.
Now we see emotional escalation disguised as legal concern. The defendant reframes himself as the victim while ignoring the actual charge. This tactic is common, shift focus from conduct to character. The judge brings the discussion back to reality. Roles, procedures, and next steps. Courts don't operate on personal labels. They operate on allegations and evidence. Calling yourself a victim doesn't make it so.
Legal advice, because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly appreciate you being fair. Yeah, because
the answer to your question is I can't answer your question because that would then be giving you legal advice, and I'm not allowed to give either side legal advice.
Okay, because in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gang mobile, and then taking them to a cage. That's the victim in this case. And the victim,
Okay,
if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor, with a police officer that's bringing the charges with the help of an attorney, and then they don't know what 241 or Section 241 Title 18 conspiracy to violate my rights, then I have serious concerns for the fairness and
The moment he accuses the prosecutor of being a criminal on the record is catastrophic. This isn't activism. It's self-destruction. The judge issues a clear warning about contempt, drawing a firm line. Courtrooms are not talk shows, and reckless accusations carry consequences. The defendant seems unaware that everything he says becomes part of the official record, shaping how he's perceived going forward.
District Court of the State of Michigan. It's located in the city of Taylor, but I don't work for the city of Taylor.
But do you see my concern for my safety?
No, I absolutely, except for the fact is, I'm presiding over the whole case. And I'm gonna make sure everybody has due process. Everybody has the same fairness to bring their case and to make sure that they can cross-examine witnesses and make sure everything is recorded by my recorder, who also has sworn an oath, and I find her to have never have broken her oath either. And so I'm just telling you, I'm gonna be doing my job. My job is to defend the Constitution, and I will be doing so. So as of today, it was set for arraignment. I have entered a not guilty as to the charges against you. And right now, I can do one of two things. One, I can set this up for a pretrial. The pretrial is something that I always afford the parties, where they can talk to one another. If they want to work something out, I have no problem with the constitutional right to enter into contracts and to do things like that. Or I can just set up for a jury trial or bench trial right now. If you want to forego any of that and say, look, I really have nothing to discuss with them, I'll just like to go to trial. So would you like to meet with the prosecutor? Well, in which case I will set this up for a settlement conference date where the two of you can discuss the matter. Or I can just set this for a jury trial or bench trial right now.
Well, I mean, I do have a couple objections to that, because I'm being labeled.
Logistics come into play, and even here ideology interferes. Refusing to provide an address under the guise of activism creates real procedural problems. Courts rely on notice, communication, and accountability. Choosing instability doesn't make you immune to process. It makes compliance harder for you. Responsibility doesn't disappear just because you don't like structure.
And that prosecutor, as long as we're going around and throwing out suspicions and alleging crimes, I'm going to allege them of the crime of the Department of Justice, Section 241, 242, Title 18, which is deprivation of rights under color of law. And I take serious issue with people acting like criminals.
Okay, so what I'm saying is this. One, I don't have jurisdiction to take your case. Two, you're citing to federal law. Three, you would have to file that in the federal court. And and all of those things are available to you. You have the right to do so and have the proper court, determine that. All right, so what I'm saying is this is a city ordinance, and I have jurisdiction over state cases and over city cases, misdemeanors. And I don't have, and what you're stating, I don't have the jurisdiction to hear. That doesn't mean that you can't bring that case in the proper court. All I'm saying is from now on, I'm just going to refer to you as Mr. Lanto. If you prefer not to be referred to as the defendant, then I'll refer to you as Mr. Lanto. The prosecutor is Mr. Dave Greco, and I'll refer to him as Mr. Greco. And that way, everyone will just refer to one another in their generally names. But what I'm asking you right now is, would you like me to set this for a settlement conference at a later date? Or would you like to set this for a bench or jury trial?
Well, I'm willing to forego any intention of criminal charges.
The hearing ends exactly where it had to. A not guilty plea entered, a settlement conference scheduled, and the court moving forward despite resistance. The system didn't bend, didn't break, and didn't engage in theatrics. It simply did its job. And that's the real lesson here. You can argue, posture, and posture some more, but procedure always wins in the end.